we have to abide by the outcome of those court matters. As you know, President Granger has said that he would be bound by the Constitution, by the directions of GCOM concerning the conduct of the elections, and the rulings of the court, the Supreme Court of Guyana. So we have before the courts three cases essentially, one by Ms. Moore, one by Mr. Jagdeo, and one by the late Mr. Holodar. Now, in Ms. Moore's case, two issues were addressed by Justice Holder dealing with jurisdiction. The first one dealt with whether the court had jurisdiction, period, to proceed to hear the matter, Ms. Moore's matter. And the other one was whether the court had jurisdiction to grant discovery of GCOM's SOPs to Mr. Jagdeo. Now, in relation to the former matter, whether the court overall had any jurisdiction to proceed to hear Ms. Moore's FDA fixed date application matter, the learned judge held that he had jurisdiction, and that was not surprising because it was a matter similar to that before the learned Chief Justice that was brought by Holodar. And the learned Chief Justice there said that the court had jurisdiction to judicially review the actions of a statutory commission or body. That is a body that had a public duty or was performing public functions. And in that case, she took jurisdiction to see whether or not GCOM had acted intra vires, that is, within their powers, or acted ultra vires and exceeded their powers. And it's the same issue before Justice Holder, and he, I would say, correctly ruled that he had jurisdiction to proceed with the matter. The other issue was whether he had jurisdiction to grant discovery of GCOM's SOPs to a political party, that Mr. Jagdeo's party, and the learned judge ruled that he didn't have also jurisdiction to so rule that GCOM's SOP should be handed to Mr. Jagdeo. Because simply that the contention is that the GCOM's SOPs are not coincident with the PPP's SOPs, and the whole question of a dispute as to the validity of the SOPs. Those issues are not for this judge. Those issues are for the election petition, and the court, I would say again, so ruled. Now, Jagdeo has appealed the ruling of the learned judge that he had no jurisdiction to proceed over, that he had jurisdiction to proceed in the matter and to hear it in Moore's matter. And that matter was appealed to the full court, and my understanding is that the learned Chief Justice herself and Justice Haranan would hear that matter, I think, on Monday. And so that case, of course, the court could rule, they are applying to the court for a stay of Justice Holder's decision that he had jurisdiction to proceed. So if the stay is refused, Justice Holder could continue to hear his matter. If the stay is granted, Justice Holder would be unable to proceed to hear the matter. Now, it's opposite that they did not appeal his refusal to grant the SOPs. Now, in the case of Mr. Jagdeo's case, Mr. Jagdeo, of course, is contending that the second declaration by the returning officer of election district number 4, Mr. Mingo, he's challenging that second declaration, and he's saying that it was invalid or fraudulent, more or less. And that matter will be coming up, I believe, on Monday for arguments before Justice Holder also. And, you know, of course, the lawyer for the Chief Election Officer, Mr. Boston, Senior Counsel, is contending that also, this whole question of whether the declaration was valid or invalid is also another question raising a dispute, and that could only be resolved at an election on an election petition. Uh, the other issue there too is the question that the question of an assurance given by the chairman of GCOM in relation to the CARICOM and other JAGBIO president agreement. And they're claiming that when they were up at the magistrate's court that Saturday on the East Bank, that some assurance was given by the chairman of GCOM then. The lawyers for GCOM and so they are contending that when you look at the transcripts don't support that contention. So those matters that we have to, those matters are in dispute. And so such dispute could only be resolved by an election petition, but at the end of the day, it's all up to the judge to make that determination. And so we all have to await the decisions and the rulings of the Lord and Judge on this point. Now the third case is that of the deceased Holodar. The question arises whether his death would affect the case. And speaking from where I sit, Mr. Holodar, deceased, had been contending that he had a legitimate expectation that the chairman of GCOM would have acted on the assurance that she gave up at the magistrate court that day as he had contended in his application. So the problem with that is that normally in a case where somebody dies, one could seek the effect of substitution of that deceased by whether a relative or some successor to his estate or her estate as the case may be. But in this case, since Mr. Holodar was saying that he had a legitimate expectation, it was his legitimate expectation, and it's only he could say to the court what were the considerations guiding his arrival at that legitimate expectation, whether it was premised on a valid basis or, on some, or whether it was on some capricious basis. So, since he is now deceased, I don't think anyone could be subrogated in his position, speaking for myself, to really say what was in Holodar's mind when he said that it was his legitimate expectation. So I'm not sure that matter could continue, but I mean, that is up to the matter. It's a matter for the court's discretion. And so these cases, for example, the appeal for the jurisdiction, if the court rules in a way that doesn't favor Mr. Jaglio, it's conceivable that he would want to appeal to the Court of Appeal and eventually to the CCJ. So these matters, people might be frustrated that it's so long after the 2nd of March and you haven't had a decision as yet. But that's the nature of our system. We are guided by the rule of law. We have a constitution that is the supreme law of the land. And our courts are there to interpret the Constitution. We are bound to abide the decisions of the court. And we all await anxiously the outcome of these matters.